All right,
Oh, who's this?
Christina Rodriguez. This is Miss French. Good morning, ma'am. You're Christina Rodriguez.
Good morning.
And this is cause number 17-27256. I'm going to take judicial notice of the court's file. You have paper there?
We're gonna go through the motion.
Okay.
You said you.
And in the file, Ms. Rodriguez was examined for competency to stand trial by Dr. Capon. I received that report dated June 22nd of 2026. The finding in that report is that Ms. Rodriguez is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor. No, Your Honor.
Then at this time, I am going to find Ms. Rodriguez is competent to stand trial. We'll move forward and will she waive the formal reading of the motion?
Yes, Your Honor.
And Ms. Rodriguez, did you swear her in?
Yes.
Okay. Even usually you don't if there's no paperwork, so I was just making sure.
Right.
Gotcha. Thank you. Ms. Rodriguez, in clause number 17-27256, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 16th of 2018 for injury to a child, elderly, or disabled individual, a second-degree felony, and that was a 10-year deferred probation. Is that correct?
Yes.
This motion alleges that you violated your probation. Count one alleges that you committed the new offense of terroristic threat, October 23rd of 2025 in Orange County, Texas. And is that true or not true?
That's not true.
Count two alleges that you committed the offense of harassment on October 23rd and 2025 in Orange County, Texas. And is that true or not true?
No, that's not true.
Count three alleges that you failed to avoid injurious or vicious habits as directed on December of 2025. You disrupted and created disturbances at the Tiger Hut in Silsbee, Texas by calling, harassing, threatening, and posting falsehoods on their business website. Is that true or not true? Count four alleges that you're behind in your court assessed fees as of March 26th of 2026 in the amount of $9,198.39. Is that true or not true?
That's true.
All right, then, did you enter your plea of true to count one freely and voluntarily? Count four freely and voluntarily. And did you plead true to that count because it's actually true?
It's true.
Then at this time, I'm going to find count four true, find that you entered that plea freely and voluntarily. Reset your case for a sentencing hearing. We'll get an updated pre-sentence report done. Ms. Malfino,
Judge Ms. French has a detailed witness list already prepared. I'll make sure that goes out whatever date the court gives me today. And if she's in trial and something else, I'm paying.
so that'll probably need to have a little bit, a couple of hours, I would think, not just a short.
Like maybe you have 4 witnesses.
Okay, so we'll get it set on a date when we have plenty of time. Anything that you think is important for Ms. Holmes to know, get that information to her. She'll present it to me on your behalf when we come back and we'll set it for a hearing.
Yes, ma'am.
Okay, you can go back with the bailiff.
Okay.
Thank you, Ms. Malfino. See, Ms. Malfino,
Yes.
on Tyree Hartley, Mr. Wilkerson sent a message that he's not going to be able to be here today.
So
He's announced ready. What is your announcement?
I really needed to speak with him this morning about an additional piece of discovery that I think he doesn't realize he's lacking. It's all that stuff we spoke with you a week or so ago about the from chamber. It's 4 agencies involved and
Right.
need to make sure that I can get back with Wendy today since he's out. I also have 2 of my lead detectives from Beaumont have sent in notice that they're on vacation all that week, but I don't want to announce not ready until maybe I can speak with him and see if he would stipulate to a couple things, but I didn't
Okay.
represent that I'm ready.
Gotcha.
Can I be ready for each, maybe
Sure.
for the time being until I can speak with him?
Yes, ma'am.
No, it's one of them. Is that
Good
your?
morning, sir. You Brian McWade?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor, we're pleading to the lesser included attempted.
Thank you.
Just need to see, make sure.
Okay, I'll be sure to add it.
Mr. McWade, in cause number 26, DCCR 0402, the state has elected to proceed on the lesser included offense of a third-degree felony, attempted aggravated assault with a deadly weapon from March 8th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Macon?
Yes, ma'am.
Do you fully understand them? Yes or no?
ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for an 8-year deferred probation. No, I'm sorry, there would be an 8-year term in prison that would be
Which
probated.
I
for
believe
8
we can
years.
do since it's an attempt, Your Honor. Typically with this offense, you
Right.
can't, but I think since we made it an attempt, we're okay.
Okay. Y'all looked at it
I,
a little bit.
a little bit, yes, Your Honor. That's
Okay.
my understanding.
All right, so what we'll do also is between now and sentencing, if everybody will double check, just so that we make sure before sentencing that we don't do something that we're not supposed to.
It's in that big green book, I think.
I'm sorry,
It's in that big green book.
yeah,
The big green book.
the big green book. All right, so it looks like the agreement is for you would be convicted with an 8-year term in prison. That would be probated for 8 years. There would be a $1,000 fine and you would be required to follow all of the rules and conditions of probation. It's checked off restitution center,
There is restitution involved, Your Honor.
but not the restitution. We don't even have that anymore. We need to change that. We don't have a
I saw the word
restitution.
restitution and checked the box.
So there's an agreement. I'm gonna write that you would pay restitution. Is that correct? And the amount determined between now and sentencing?
Yes, Sean.
Is that, you understand that as well? Do you also understand if you're not a US citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. McWade's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back for later for sentencing. That'll also give everyone an opportunity to figure out that restitution amount. And we'll double check that based on what the nature of this offense is, that we can do that convicted probation. I want everybody to double check that as well. So with regard to a bond based on the nature of this plea agreement, Mr. Nichols, what's the state's?
Your Honor, he served 150 days in jail for this case. We don't oppose a bond pre-sentencing.
So, Mr. McWade, what I'm going to do in your case, based on the nature of your plea agreement, is reduce your bond to $1,000. If you make that bond, there's a couple of things that are very important. The first is that you go directly to the probation department when you're released so you can get that pre-sentence report done. If you don't do that, you run the risk of me not accepting the plea agreement and things could be worse. Also, if you are arrested for anything between now and when you come back for sentencing, you run the risk of me not accepting the plea agreement. And then the last thing would be a condition of your bond is that you have absolutely no contact or communication with Simone Mullins. That's obviously communication in person, but it's anyway, you can't send messages through any type of social media or other people or anything like that. If you do, and I find out about it, then your bond will be raised, you'll be back in jail, and I probably won't accept the agreement. All right, any questions? All right, good luck to you, sir. You can go back with the bailiff. We'll see you at sentencing.
Thank you, Your Honor. Let's make it.
Could you please make a note? Because I feel like. Good morning, you're Dondre Blewett.
Yes, no.
And Mr. Blewett's case in cause number 26 DCCR 0362 set for trial to begin with jury selection on August 17th. And what is the announcement?
Your Honor, I recently asked Mr. Coleman for some additional discovery involving a complaining witness. I sent him an email on. This was Thursday, the 30th. I haven't heard back from him yet. I think it's pertinent to our case because of what it involves a complaining witness. So until I have an answer on that, I don't think I can make an announcement.
Mr. Nichols, any?
I show that some reports were added back in April, but nothing in the last week. So I'll have to check on that, Judge.
Okay.
I don't mind chasing him down. I know he's not in your court anymore. That's been.
Yeah, we're working on some of those issues. So why don't I do this? I'm just going to I'm not going to reset it at this point. If you can get with Mr.
We've got time,
Coleman,
Jason.
we've
I
got
can
2
do that.
weeks for you guys to, if if you'll kind of help out with that, get that information to Mr. Kelly, and then kind of let me know where we are. It's not the trial oldest one, but others are kind of falling apart, so you never know. Yeah, so I'll number it, but I'll also make a notation of that. Thank you.
Thank you,
Mr.
Aaron.
Nichols.
Sure, thank you.
You can go back with the bailiff. Good morning. Are you Kavan Sonia?
Yes, ma'am.
And Mr. Sonia's case in cause number 25 DCCR 1530 is set for trial to begin with jury selection Monday, the 17th of August. And what is the announcement?
Judge, the state's ready. On the 16th of July, I filed a notice of intent to use business record affidavit. There's about 1,200 pages of medical records that have been added to discovery a few weeks ago. I'll, in candor to the court, we'll have to proceed most likely without the complaining witness. And that's how we're going to be presenting this case.
Okay.
So we can be ready.
Okay. Sounds good. And that was done a few weeks ago.
I believe the 16th was when it was filed.
Okay. Mr. Burbank?
Your Honor, if you would call the 260th court, I do have a trial set. In Judge Parkhurst, it's a murder trial.
Okay.
And I can be ready, whoever wants me.
Okay. Sounds good. I'll look at our numbering on this one and take that into consideration. And if for some reason it looks like you're at the top, I'll see how old that one is and things like that. And we'll work it out and let you know.
Yes, sir.
All right. Thank you. You can go back with the bailiff. Good morning, sir. You're Brandon Creation.
Yes, ma'am.
And this is cause number 26 DCCR 1178. Mr. Creation is charged with murder. And what is the announcement?
Your Honor, there are a couple of things, a couple of items that are missing, not that it's the state's fault that I need to request. And there's also a guardhouse video that I'd like to schedule a time to be with Mr. Creation.
Okay. And go ahead.
I'm sorry
Yes,
to
ma'am.
interrupt. I certainly concur with Ms. Perazzo about that. I am still in the process of receiving discovery. Some scientific lab paperwork came in a week or so ago. We made sure to add that to the portal. This also involves the conflict we mentioned to the court yesterday that we've resolved with another individual who was before you that is a family member. So now that we have cleared up that issue, if you'll recall what I'm talking about, and I can fill you in on it.
Yeah.
It would allow me the opportunity now, as is my custom, sit down with the family. I wanted
Yes.
to do that before the court first, before I set that meeting, but I would like a
Okay.
chance to do that, make sure if Ms. Perazzo, as she usually does, sends me a list of what she needs, we'll go through our files together.
Okay, well, sounds good. And so what we'll do is just get with Ms. Holmes and we'll have Mr. Creation brought over. You guys can watch
make
that
that
video down here in the jury room in the next couple of weeks and get everything hopefully together between now and that next court date. And we'll see where we are at the next court date.
Yes,
All
ma'am.
right, you can go back with the bailiff, sir. And then you have Thaddeus McCray. Good morning, you're Thaddeus McCray. And Mr. McCray in cause number 26 DCCR 0399 is charged with the first degree felony offense of murder. There's also a MTRP that we're carrying along with that. And so what is the announcement on the murder?
So, Your Honor, I had requested some additional discovery from the state. They did provide that, but due to other scheduling matters and issues, I have not had an opportunity to review that with Mr. McCray. So if I could just have one more reset so we could.
Is there anything else that you guys are waiting on at this point?
Not that I'm aware of.
Okay.
They have produced everything. but I-
Perfect. So what we'll do, this will be the last reset. Ms. Perazzo will be out to see you to go over everything that she has received from the district attorney's office, relay whatever offer there is. When we come back, if there's an acceptance of that offer, we'll take care of it. If not, we'll get you placed on the trial docket after that.
Yes,
Okay?
thank you so much.
Yes, ma'am. You can go back with the bailiff.
Oh, yeah.
Good morning, you're Brendan Ernest. And Mr. Ernest was previously in court. Look this way, pay attention to me. And cause numbers 26 DCCR 0429, 0430, and 0908. Entered pleas of guilty to aggravated robbery, obstruction or retaliation, and robbery. I've received the pre-sentence report. Have y'all both had an opportunity to review that report?
We have, Your Honor. Yes.
In addition to that, I've received and reviewed jail incident reports. Have y'all had an opportunity to review those?
We have. Yes, Judge.
All right, I am not inclined at this time to accept this plea agreement. based on the information of the offenses themselves, as well as the additional information that the detective has relayed with regards.
This hearing has just become far more serious for Brendan Ernest. He has already entered guilty pleas in 3 cases involving aggravated robbery, obstruction or retaliation, and robbery, and the court now has both the pre-sentence report and jail incident reports in front of it. That means the judge is not looking only at the negotiated agreement. She is also weighing what the reports say about the offenses and Ernest's conduct while in custody. The defense is about to argue that his age matters. He is 17, these are his first adult cases, and counsel wants the court to consider probation rather than prison. But the judge is signaling that the information she has reviewed may change the direction of this hearing. The key question now is simple. Will the court accept the negotiated outcome, or will the new
Of the things that Mr. Ernest has been involved in, as well as what he's doing out at the jail. So y'all want to talk to me about
And
how to
Judge,
change my mind?
I don't know that this is gonna change your mind, but I meant to object to the part of Officer Jackson's statement as far as any uncharged conduct that happened while he was a juvenile in 2023.
I think that it's relevant and it's information that's important for me to know. If he's had contacts just because he was a juvenile and certain people didn't follow through because he was a juvenile and wanted to give him that opportunity, I don't think he gets to now say, well, I didn't get in trouble. So, because somebody was nice and gave him some opportunity back then.
Well, then what I would say, Judge, is this is a youthful offender. He's 17 years old. These are his first cases. Some juvenile history that like it was successful completion of probation. He's never been on probation as an either felony or misdemeanor.
Sure.
The alternative, Judge, I know is prison. And certainly there's a lot of violent crime going on in our community. It's for a first offense. I have a hard time sending people to prison for their first offenses, even though these are serious offenses. Some of them do deserve to go to prison for the first offense, but a 17-year-old first contact as an adult, I would ask the court to consider following the agreement with some sort of. I know the probation recommends MRT. I've also talked with Mr. Ernest about ISF, and he's
Here
willing.
you go. 17.
Yeah.
So here's my thought on something like this, based on the nature of these offenses and based on what he said to the police that day, which gives me a huge amount of concern. I'm not going to repeat the words here about what he said he was going to go back and do to that clerk. I'm not letting him out on today, not doing it. If a jury wants to do that, I'm not one to throw things on y'all know how I am about my trial docket. I'm not inclined to just throw things on the trial docket, but I think this is one for the community of Jefferson County to decide instead of us, because I'm not going to give them probation. If they choose to do that, then that's going to be up to them. But I don't think this is in any way someone deserving of probation, regardless of his age, at least at this time. If he had been not acting like a fool in jail, maybe I'd decide differently. But he hasn't changed anything. You haven't changed anything. I'm talking like you're not here. You haven't changed anything about your behavior. You're out in our jail, acting like an idiot with the rest of the youthful people out there, doing nothing but giving those people that are going to work every day crap. And if you think that's going to get you somewhere and you're going to get to go home today, now you see what it's going to do. It's not. You're going to get set for trial. And when you come to trial, if you're found guilty of these offenses, a jury's going to get to see all of that information about how you're acting at our jail. So you need to keep that in mind between now and when you come back to trial, because if you're going to be asking a jury to give you probation and you've been acting like this, highly unlikely. All right. So what I'm going to do is I'm going to set it on the trial docket. Mr. Ernest, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I'll appoint another attorney today who can begin preparation for trial a little quicker. Is that okay with you?
My decision.
Yep. If you want to keep Mr. Rojas, you can keep him. If you want to get someone else, you can ask for that as well. All right, so Mr. Rojas will begin preparation for trial. And, there's things, if y'all want to go to a jury for punishment only and accept responsibility, that's an option. But talk to him about that, but I'm not going to do it. All right, thank you. I appreciate what y'all did, and I don't like getting involved too much in these
Well, I
negotiations,
mean,
but.
the offer was obviously made because of his age.
Sure, no, I completely understand that, and I know you didn't know probably all the information, Mr. Smith, once it came out in the pre-sentence report about some of the specific facts of the case, as well as some of that history that gives me concern, as well as this jail stuff, so I'm not saying you shouldn't have given the offer, I'm just saying there's a lot of things you probably didn't know as well, so. All right, go back with the bailiff. Mr. Jones, in cause number 26 DCCR 0842, you're charged with the state jail felony offense of theft with previous theft convictions, and that's from March 13th of 2026. Your indictment alleges that you were previously convicted of theft February 8th of 2012, and then again June 3rd of 2013. And how do you plead to that charge?
Yes.
Not guilty?
Guilty.
Guilty. And are those prior convictions true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily? And did you plead guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find those 2 prior convictions true, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft with previous convictions, sentence you in accordance with your agreement to a term of 6 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas.
Yeah.
All right, good luck to you, sir. You can go back with the bailiff. And then you've got Lorenzo Thomas.
Bill Thomas.
Good morning, sir. Are you Lorenzo Thomas?
Yeah.
And this is cause number 2240120. And Mr. Thomas is on probation for aggravated assault with a deadly weapon. And there's a motion to revoke that unadjudicated probation. What is the announcement?
Judge, it's coming to the attention of the state through Mr. Burrell that the defendant has, in addition to the Jasper County cases alleged in the motion, a new offense of evading detention felony in Harris County. I believe felony, Harris County. There's an active warrant for that now. I can either file a first amended motion to include that now that we have that offense material. We can allow him to go on that warrant, whatever the court wants to do, or go through this motion and see where we are. And I can still add it, but we kind of know where we were, whatever you want me to do.
I mean, I guess if it is going to be the state's position based on all of that for me to revoke
Yes, it
the
will.
probation, then I think I need all the information. So first amended would probably be the best way to go. I know getting officers from Harris County might be difficult, but my thought is let's get it filed.
Okay.
Get an offer, get whatever discovery materials you can get on that to Mr. Rojas. If there's an agreement at the next court date, great. If not,
So
we'll get pleas of true or not true and then set a hearing and see who you can get to come. Possibly, and if there's an agreement to take any witness on Zoom, we can still do that. especially on these hearings, but if that would be up to Mr. Rojas, you guys, and I'm not trying to pressure you to do it, but y'all can visit about that. If that's an option, we can take some certain things up that way as well.
Sure, I'll get it filed this week.
Perfect. All right, we'll just do a reset then for that. Thank you, Mr. Burrell. It's good to see you tonight.
Thank you, Judge.
At this point in the hearing, the biggest turning point happens. Judge Raquel West explains that she is not prepared to accept the plea agreement after reviewing the nature of the offenses, the pre-sentence information, and additional concerns related to the defendant's conduct. This is a critical moment because plea agreements are not automatically approved by the court. The judge has the responsibility to consider the information presented before making a final decision. The defense argues for another opportunity, highlighting the defendant's age and previous history, but the judge focuses on the seriousness of the allegations and the information brought before the court. Do you think a judge should follow a negotiated agreement, or should new information change the outcome? The court now has to decide what happens next.
And my mama got to take care of. I'm just tired. And I want the opportunity to get my life together. I'm tired of this. I'm tired of this. I'm old. I missed my daughter's graduation. She spoke at Westbrook graduation. I was not there. I'm tired. My baby asked me why I'm the only mom. I'm not at mom's and muffins. That is embarrassing for my kids. I want to go for my kids. That's what a chance to do for me. You know, Mama, thank you.
Good morning. Are you Matthew Wadsworth?
Yes.
And Mr. Wadsworth was previously in court and entered a plea of guilty to the second-degree felony offense of aggravated assault with a deadly weapon. There was an agreement for a cap of 8 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Yes, sir.
Are there any additions or corrections?
Oh, yeah.
Not from this one.
All right, Mr. Rojas, you may proceed.
And he tells me he's ready to make that change, and he does have some statements to make to you at the appropriate time.
It's a straight A's. I was sexually abused. My parents were drug addicts. I went to prison. You guys forgot something. I hope it don't hurt me, but I got beat up. I had a robbery in 1992. When I got out from that robbery until 2000, when you started 2002, yes, ma'am. I stayed out of trouble again because I was on medication. It's been my whole life. It's been the pattern of my life. I'm on my medication. I'm a great guy. I'm a journeyman electrician. I'm a father. I'm a grandfather. I spend time with my kids. If I'm off of them, and the reason I got off of them and this offense happened is I was hearing voices. I thought my roommate was holding my girlfriend hostage. It says I hit him with a bat, but it was my walking cane. It wasn't a bat. And I did hit him, and I felt horrible because I found what was going on. But in my head, our house burned down, dogs died, and I just kind of went crazy. But I did stop. I did tell in 2019. I'm sorry, 19. I said I'm tired of this, and I'm gonna stay on my medications. When the house burned down, all my medications went with it. My truck, my tools, and everything. And I was just barely making it. And I honestly thought my roommate was holding my girlfriend against her will and hostage. And we started fighting. I was losing, and I said, if you do give me the chance, what I need is some help staying on my meds. Because I start feeling like I'm doing better sometimes. And then I stopped taking them. When I stopped taking them, I hear voices, and I can't tell if it's mine or if it's somebody else, or I can't tell.
So, but Mr. White, even if I give you a probation, it's only for so long. At some point, you have to stay on your own meds, and you can't require someone else to force you to do that and take a chance with society and the community of you hurting someone else. Honestly, I'm not sure, but I honestly think 21 felony convictions. 21. I know, wow, right?
I'm not.
You still have one pending in Indiana. And out of the, and in addition to the 21 and the one pending, you have 16 others that were dismissed because of plea agreements, and things like that. So that's 38 felonies. The last, and I get a lot of this was from '02.
I believe probation is absolutely right, that jail time and probation has not been a deterrent for him. He's not made probation. We would ask for the 8 years to DC.
Mr. Wadsworth, again, like I stated before, to Mr. Rojas, the fact that he was able to negotiate for you a cap of 8 years on a second-degree felony with your criminal history, there's part of me today that was considering not even accepting this plea agreement. Because I think with your criminal history, personally, I think it's ridiculous.
I have to understand.
So I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find that you entered your plea of guilty. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. There's help in prison for you with medication. It's going to be up to you when you get out to either change your life if you really want to or not, and you'll have to do that on your own. All right, good luck to you, sir. You can go back with the bailiff. All right, are you Rebecca Rideau?
Yes, ma'am.
And Ms. Rideau was previously in court, entered pleas of guilty in cause numbers 23-0928, 23-2106, 23-2107, and 24-1925. All of those were theft of property with previous convictions. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
I have defense of.
State has, Judge.
And there was no agreement. This was just open to the court. Is that correct?
Yes, Your Honor.
I believe so, Your Honor. I didn't represent her at the stage where she entered the plea.
Okay.
My understanding is that
They were open. And are there any additions or corrections to the pre-sentence report?
None from defendant.
Not from the state, Judge.
Your Honor, I would just say that seems to be an aberrant practice as far as the harshness that the state is attempting to exert on this defendant. And I don't know that it stands out from the queue of other cases before this court to deserve such treatment, but it is what it is. I would just observe, first of all, regarding the state's posture on consecutive sentences to denial of discretionary jail credit. The defense certainly has criminal history, but it's not to such an extent or degree in the circumstances the individual cases aren't such to the extreme degree that it would warrant accumulation, and certainly the denial of her jail credit is something that is problematic. I don't know exactly which jail credit the state is attempting to deny her, but obviously if she's been in pretrial detention on these cases, it seemed that she would be entitled to that jail credit without much original discharge. And there was notations there as far as the pre-sentence report that would involve some health issues. I believe her to be mentally competent. Now, I, of course, wasn't her attorney when she entered the plea, but I would assume that she has been competent then as well. Although, as I said, she does have mental health history. I think that plays into her present situation with the theft cases that she has. You will note in the pre-sentence report where it's indicated that she was unable to afford the mental health treatment and the pharmacological remedies that are provided through prescriptions, and that she was self-medicating and had turned to theft in an attempt to maintain
funds necessary to self-medicate.
Then my mom got to take care of. I'm just tired. And I want the opportunity to get my life together. I'm tired of this. I'm tired of this. I miss my daughter's graduation. She spoke at West graduation. I was not there. I'm tired. My baby asked me why I'm the only mom. I'm not at mom's and muffins. That is embarrassing for my kids. I want to go for my kids. That's what a chance to do for me. You know, Mama, thank you. I want to thank you.
Sure. So there was a robbery that you got some time for in 21, and then you're here now on 4 more theft cases. And so, I mean, it's unfortunate and it's sad for your family, but no one put you here but yourself. Mr.
Judge, you
Coleman, I know what you're...
Yeah, you've essentially hit the things that I want to hit. That in addition to what I put in my sentencing memo, I won't belabor that, Judge. The only thing I would add is she says she's tired of this. I tell you who else is tired of this. It's our local store owners and business owners who are tired of people just walking in and taking what they want from them. She stole from a sporting goods store, from JCPenney, from another clothing store on a couple of occasions. They're tired of it too. They're the same old song. Just different defendant. I apologize. Give me another chance. I've got all these issues. In fact, yeah, I go one step further than the same old song. It's the greatest hits, Judge. It's what you hear time and time again. And I'm sure she said it back, but
I can't give the max and do that.
that's my understanding.
That's your understanding.
Yes, that's it in a nutshell, Judge. And I just say this is a case for that to be considered. And I also say this is the appropriate case to accumulate her sentence, Judge. She needs, in my opinion, some stronger medicine than what she's received in the past in order to impress upon her the fact that she needs to stop engaging in this kind of behavior, Judge. Thanks, that's all I have.
Thank you.
I would just argue from the standpoint of equal protection as far as the other defendants listed.
Well, so here's... Speak up so she can hear.
I would argue from the standpoint of equal protection of laws, Your Honor. What distinguishes her from the other defendants that have been before this court and are similarly situated with similar criminal histories?
Well, here's where I am on this. I don't disagree with Mr. Coleman. I appreciate that he's gone out and tried to figure out some stronger things to do on some of these cases where we are stuck with state jail felonies. I've been very frustrated with that in the past. I don't know that this is the one to start with either necessarily, but it's not going to be out of the realm of possibility, depending on someone's criminal history, what their prior sentences were, and I don't fully disagree that this isn't one of them. I'm not going to do that this time, but I do appreciate the thought that went into this and don't necessarily disagree that there's going to be a time that this might happen, including to you if you continue to do what you've been doing for your whole life. Because if you're back in here after today on a theft, I can assure you that Mr. Coleman will remind me what he asked me to do that I didn't do. And I will on that. Do you understand? So if you want to be there for your kids, then you got to figure out something other than stealing. I'm going to find in all of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 23, DCCR 0928, find you guilty of the state jail felony of theft of property. Sentence you to a term of 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 23, DCCR 2106, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 23, DCCR 2107, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to a term of 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 24, DCCR 1925, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to a term of 24 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases, I am going to run them concurrently, which means together at the same time. Part of the reason I did the 24 months is because I'm going to see that when you come back, that this is the max on a state jail felony you can get. So next time, whoever's here, if it's me or someone else, is going to see that you have progressively gotten worse, your sentences have gotten worse, and when someone like Mr. Coleman files something asking that these run consecutive or that we deny credit, that's likely to happen. I'm handing you in all 4 of your cases the trial court certifications. These show that these were not agreements, and so you have not waived your right to appeal. You can talk to Mr. Kimler about that. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Kimler.
The court's decision in this hearing is now clear. Brendan Ernest is not being released, and the judge is not willing to give him the probationary outcome that had been presented. Instead, she directs that the cases be placed on the trial docket and tells Ernest that a jury may ultimately hear information about his conduct if punishment becomes an issue. The judge also allows his appointed attorney to continue preparing the case for trial. Importantly, this is not a final prison sentence in this hearing. The judge does not impose a term of years here. The major consequence is that the negotiated path toward probation has been rejected by the court at this stage, and the case moves toward trial. For a 17-year-old defendant facing serious charges, that is a major shift in direction and a reminder that court